Mr. Borg.
Good morning, Mr. Chairman and Ranking Member Waters and members of the subcommittee. Thank you for the invitation. I'm honored to be back before the committee in these hearings. I am Joe Borg, the State Securities Regular for the state of Alabama. Our office has administrative, civil, and criminal authority under the Securities Act, and in addition to the examinations of audits of broker-dealers and investment advisors, we do quite a bit of investigation on Ponzi, pyramids, illegal blind pools, offshore and tax scams, fraudulent private placements under Reg D, oil and gas, and everything. I have filed my written testimony with the committee, and I will briefly go over some of the points in that, and I will try and skip over some of the points that were discussed in the earlier panel. Direct equity investments, retirement plans, mutual funds, and similar investment vehicles have become the primary method by which Americans save for their future, accumulate wealth, and plan for a secure retirement. Financial fraud in any form threatens the future security and well-being of our citizens, destroys the hopes and dreams of families, and destroys what should be the golden years of our life-experienced seniors. As I previously testified back in September, the task force was charged to look at 12 particular areas, and out of that, we have a report covering 15 specific recommendations. The task force was split into two working groups. My particular subgroup covered recommendations 1 through 4, 14, and 15. So I will briefly talk about those particular points. The $1.3 million reflects my original opinion of an increase to $1 million plus an adjustment for indexing to inflation. Americans are looking to the markets and investments to secure their long-term future goals. The days of realizing the American dream of a secure future by saving only in a bank account or a certificate of deposit are long gone, especially with current rates below 40 basis points. Interestingly enough, in meeting with the federal banking authorities, they had concerns about SIPC diverging from the historical relationship between FDIC and SIPC protection levels. In my opinion, the historical tie between SIPC and FDIC levels have contributed to the lack of understanding of the differences of FDIC and SIPC coverage. The insurance of FDIC to bank accounts and the coverage, non-insurance, of SIPC to securities is fundamentally different both in statutory application and practical application, at least under existing law. The reality is that my future security in retirement is not going to come from my savings and checking account, but from my investment accounts. Recommendation number 2 had to do with eliminating the distinction for cash and securities. This is outdated. It's meaningless in today's markets. Consider that money market accounts were relatively small in 1978. Now they're $2.7 trillion. Brokerage cash sweeps into money market accounts or bank accounts overnight and back and forth, with substantial investor cash routinely held in brokerage accounts. Those funds deserve the full amount of SIPC protection. This distinction has caused inconsistent court decisions, investor confusion, and in some cases loss of customer funds. Interestingly enough, the Canadian counterpart to SIPC did away with the distinction back in 1998. Again, banking authorities expressed concerns that SIPC will offer greater protection against cash losses than FDIC. This is an artificial connection. And again, maintaining parity does not benefit investors. The recommendation allows the realities of today's markets to determine the actual and appropriate need for the benefit of all investors. Recommendation 3 had to do with the pension funds on a pass-through basis. There's a lot of Americans whose investments are not right now covered by SIPC protection, that they should not be discriminated against because they have generally small accounts, they're part of a defined benefit, defined contribution, or a deferred profit-sharing plan. The recommendations made comports with the trust and fiduciary provisions under ERISA, and we also took into consideration that certain pension plans and employee benefit plans have been covered by FDIC and NCUA on a pass-through basis since 1978. On the minimum assessments, according to the staff at SIPC, 25% of the membership paid a flat $150 based on net operating revenues. After Dodd-Frank, the 0.02% of gross revenues, many of the same members are actually going to pay less than $150. I think this has to do with accounting issues. If members are utilizing SIPC in marketing materials and benefiting from the SIPC program, they should pay some minimum amount. I personally thought the $1,000 was a little low, but the general consensus was $1,000 would be reasonable in the current environment. The task force also discussed whether mutual fund dealers and assessments on mutual fund reserves should be included. SIPC currently exempts mutual fund revenues. Representatives of the mutual fund industry made a case that there was no significant history of losses to investors. I did not agree with the majority of the task force not to assess mutual fund revenues because the mutual fund industry utilizes the SIPC logo, touts the SIPC coverage, and billions of dollars of mutual fund shares are held in street name. However, the fact is there's a history of minimal losses, and that was persuasive to the majority of the task force, and I respect the decision. Concerning international relations, it's a global economy. Geographical boundaries have no meaning. Cross-border effects of a failure like a Lehman or a Global have local, national, and international implications. The resolution depends on the respective national jurisdictions. That just doesn't work. The task force recommendation encourages SIPC to elevate the program in taking the lead in development a new international association. I think investor education has already been covered. I proposed a suggestion with regard to adding information into brokerage accounts. The task force considered that recommendation, but were unable to determine the cost. The issue is left with the SIPC board. The invitation also asked for views on pending legislation. I will try and cover that very quickly. The purpose of fraud is simple: deprive honest people of their funds to benefit the crooks. Look, in a perfect world, we want anyone so injured to get back what they lost. The question is it the actual investment that was stolen and distributed as profits to other victims, less the amount taken by the crook, or what was promised, that is, the representations of potential profit? Our office investigates numerous Ponzi pyramids and other scams. I currently have 48 defendants awaiting trial for various forms of security fraud right now, mostly Ponzi's and pyramids and that type. The past year we've convicted 16. The problem's always the same: limited assets to distribute. And while the intent of 757 is noble, I think it is not equitable and confers an unequal benefit to some victims over the other. And unfortunately, early investors may benefit at the expense of later investors and may receive distributions in excess. So with a limited amount of assets to distribute, we must find a way to treat every investor equitably by first attempting to make everyone whole on their initial investment. That's the amount invested minus amount received equals actual cash lost. Unless there's an endless supply of funds to pay promised returns, it becomes impossible from assets available to cover all promises. The fundamental problem with the last statement approach is that when thievery is involved, the statements will match the fraudulent misrepresentations, historical or otherwise, regardless of reasonableness, market conditions, or reality. And H.R. 757 attempts to fix a terrible problem. I have a suggestion with part of it. During the September 23rd, 2010 hearings, Professor Coffey and I will give most credit to Professor Coffey, it was his idea. Here's a suggestion to consider the creation of a de minimis exception instructing a SIPC trustee not to bring a suit against persons whose withdrawals exceeded their investment by a set amount, a given amount. This would give peace of mind to many, but would not impede the trustee in his pursuit of the very large net winners. Another possible exemption is giving early investors credit for the imputed interest on their investments. Such amounts should not be regarded as fictitious profits. Congress can immunize some minimum amount of rate of return from the concept of fictitious profits. I don't know what that rate would be, 5%, 7%, 2%, or adjusted to some sort of standardized index. But whatever the basis is used, it should maintain equitable balance between the victims of a Ponzi scheme. H.R. 1987 contains similar concepts as H.R. 757. My commentary would be the same. I would say, again, there's no real profits in a Ponzi scheme, and payments to early investors are proceeds of a crime, unbeknownst to both the earlier and later investors. For a second, let me discuss indirect...
Well, before we do that second, since you're 4 minutes over time, let us allow the other members of the panel to do that, and we'll come back.
That'd be fine, sir.